we're putting on our legal investigator hats and stepping back in time to look at a really profound and honestly pretty unsettling contradiction. We're going to examine the massive gap between the incredibly high-minded, universal language of international humanitarian law and the brutal, lived reality on the ground for colonized, enslaved, and indigenous peoples. You know, if you study law or if you advocate for human rights, you already know that a law is really only as powerful as how it's applied. So today we're diving into what actually happens when the legal framework of human rights is deliberately designed with blinders on, creating this devastating dual reality.
All right, let's jump right into this glaring foundational contradiction. On one hand, you have this concept of the lawful combatant. Think of a recognized soldier or a militia member fighting for their homeland. Under international law, that person gets legal protection. But then, look at the legal categories colonizing forces actually used on the ground. Terms like natural slave or savage. By legally defining indigenous and enslaved populations as something completely different from human combatants, colonizing powers could just totally strip them of those fundamental humanitarian protections. It wasn't an accident. It was a jurisdictional loophole deliberately used to permit atrocities.
To really grasp this, we first need to establish our legal baseline. So let's look at the core protections guaranteed by the Geneva Convention regarding prisoners of war. This benchmark sets some absolute terms. Under Article 13, prisoners must at all times be humanely treated, and they are strictly protected against physical mutilation. Article 14 says they're entitled to respect for their person, and then there's Article 16, which is huge. It guarantees treatment without adverse distinction based on race. These are the absolute bedrock principles of international humanitarian law. They represent the absolute highest ideals of how we should treat each other, even during the literal worst of circumstances, like armed conflict.
And this specific provision brilliantly illustrates exactly who this law was designed to shield. Article 4.6 of the Convention explicitly extends prisoner of war status to local inhabitants who spontaneously take up arms to resist an invading force. So even if you're just an unorganized civilian fighting back to defend your home against an approaching enemy, international law is supposed to completely protect you. Now, as legal-minded viewers, you're probably already thinking, wait, locals fighting off an invading force, that perfectly describes the resistance of indigenous peoples across the Americas. You'd be totally right. But as we're going to see, the application of this law was entirely selective.
To see how this nice, neat legal theory violently collides with historical reality, we're going to look at the accounts detailed in texts like Exterminate Them and American Holocaust during the California Gold Rush. Now, popular history usually paints this era as this grand, adventurous frontier expansion, but the legal and lived reality? It was an invasion. When Native people in California and across the Americas fought to defend their lands, their resources, and their families from heavily armed prospectors and militias, well, they were engaging in precisely the kind of defensive warfare outlined in the Geneva Conventions. And yet, they were granted literally none of the legal protections.
Just to give you a sense of the sheer scale of this resistance, consider this incredible historical account from a Spanish conquistador named Bernal Díaz del Castillo. He wrote that indigenous people resisted with a level of intensity that genuinely shocked the European invaders. He noted they fought right through cannon fire and muskets, maintaining close ranks. By every single objective measure, they were an organized, fiercely determined defending military force. They were combatants fighting an invader. But because European legal systems had already preemptively categorized them as savages instead of soldiers, their courageous defense was legally treated more like a pest infestation than a legitimate war.
And that brings us to a stark juxtaposition that really highlights the grim reality of this legal exclusion. Remember our benchmark, Geneva Article 13 explicitly forbidding physical mutilation? Well, contrast that with the lived reality of the conquistador Pedro de Valdivia. He actually bragged in a letter to Charles V that he captured survivors of an indigenous defense force in Chile and legally ordered 200 of them to have their hands and noses cut off. His justification? Contumacy, basically for being rebellious and for not acting like the natural slaves that Spanish law had declared them to be. This wasn't some rogue criminal acting out. This was a legally sanctioned punishment ordered by an official representative of an empire.
And it's crucial to understand that this legalized cruelty extended directly to the enslavement of African peoples as well. If we look at UNESCO's scientific cultural slave trade research, the timeline is horrifying. The transatlantic slave trade was not some chaotic rogue pirate operation. Not at all. It was a highly regulated, internationally recognized legal system based on state-sponsored treaties. The asiento system literally involved the kings of Spain issuing formal legal monopoly licenses to German, Portuguese, French, and English corporations. The atrocity wasn't just tolerated, it was fully legalized, bureaucratized, and permanently enshrined in international treaties like the Treaty of Utrecht.
We see that exact same weaponization of the law right here in the United States.
Take California in 1850. They passed something called the Act for the Government and Protection of Indians. I mean, the title sounds like a piece of humanitarian law, right? But the actual text of the law provided the formal legal stamp of approval for the kidnapping and forced indenture of Native adults and children. It legally insulated mass removal and chattel slavery. The law basically just required that a local justice of the peace be convinced a Native child wasn't obtained by force, which is a pretty trivial hurdle when the child's parents had already been murdered or terrorized by militias. The law itself was the mechanism for the atrocity.
So how on earth did legally educated, supposed rule of law men justify all this? They did it by manipulating legal definitions. To bypass the humanitarian norms of their own legal and religious traditions, colonial powers simply redefined the victims. Spanish conquerors pulled from frameworks dating all the way back to Aristotle to legally classify indigenous people as irrational or natural slaves. Later on, Anglo-Americans, who were more interested in taking land than labor, shifted the legal terminology entirely, defining Native Americans in court as Satan's helpers, wolves, and vermin. By officially defining these populations with these horrific, subhuman terms, governments successfully bypassed any moral or legal obligation to treat them as human beings. It made violence against them perfectly technically legal.
The generational impact of these legal frameworks was just unfathomably devastating. Just consider this staggering figure: 95%. According to historical demographers studying the events detailed in American Holocaust, a 95% post-Columbian depopulation rate is now considered a working rule of thumb across the Americas. Think about that. For every 20 Native people alive at the moment of European contact, only one stood in their place when the massacres, forced labor, and introduced diseases had run their course. For researchers looking at this data, this isn't just a tragedy of biology. They conclude it is the most massive act of genocide in world history. And the entire thing was facilitated and insulated by the legal frameworks of conquering nations.
To really visualize what this devastation looked like on a localized scale, let's zoom back in on California during the Gold Rush era. Before 1848, the Native population in the region was at least 120,000 strong. By the year 1900, following decades of legally sanctioned massacres, state-funded militia raids, and legalized enslavement, that population plummeted to roughly 17,000. That is not just a natural demographic shift, that is the visual, numerical evidence of a policy of extermination carried out entirely under the watchful approving eye of state and federal law.
Which brings us right to the absolute crux of this explainer. There is a profound, echoing gap between the paper rights drafted in places like Geneva and the lived reality of the descendants of colonized, enslaved, and indigenous peoples today. You know, the trauma of these legally insulated atrocities didn't just evaporate the moment treaties were signed or when the laws were eventually taken off the books. The loss of land, the destruction of leadership, the intergenerational economic devastation, these are direct inheritances of a legal system that was literally designed from the ground up to protect the colonizer and exploit the colonized. So, as legal minds, as human rights advocates, and as students of history, we're left staring at a pretty critical question. What does reparative international law actually look like? How does a global legal system, one that absolutely prides itself on universal human rights today, reconcile with its own foundational legacy of deliberate legalized exclusion? We really can't just celebrate the Geneva Conventions without also taking a hard look at the populations those very conventions intentionally left out in the cold.
Because true legal repair demands a lot more than just having modern equality on paper. It requires us to explicitly acknowledge that these historical atrocities were not just chaotic accidents of war. They were enacted through and protected by the law itself. If we want to transform international law from an instrument of selective protection into one of true universal justice, we have to reconstruct our legal frameworks to finally bridge that gap between paper and reality. It requires dismantling the enduring legal fictions of colonialism to ensure the rights of descendants are finally respected and repaired. Which leaves us with one final urgent question to think about. If our modern institutions of global justice were built on a foundation of deliberate exclusion, can they ever truly be reformed from the inside? Or do we need an entirely new architecture of international law?
Hey there, glad you stopped by. If you're feeling the vibe, stick around for a little while. Don't forget to like